Arkansas has one of the most landlord-friendly lease termination frameworks in the entire country, and the process here operates under a legal structure that's fundamentally different from most other states. As we've discussed in our other Arkansas videos, Arkansas is one of only a few states that has not adopted a version of the Uniform Residential Landlord and Tenant Act, which means the landlord-tenant relationship is governed by a combination of Arkansas Code, Title 18, Chapter 17, common law principles, and the terms of the lease agreement. The most distinctive feature of Arkansas law, and one that sets it apart from every other state, is the state's criminal eviction statute. Under Arkansas Code, Section 18 to 16-101, a tenant who fails to vacate after receiving proper notice can be charged with a criminal misdemeanor. While the practical use of this provision has been the subject of legal challenges and political debate, it remains part of Arkansas law and reflects the state's historically strong property rights orientation. Let's start with no-cause termination. For month-to-month tenancies, Arkansas requires either party to provide at least 1 full month's written notice before the termination date. The notice must be given before the beginning of the next rental period. So if rent is due on the 1st and you want the tenancy to end on the last day of March, you need to deliver notice before March 1st. The notice should be in writing, should clearly identify the property and the termination date, and should be delivered by a method that can be documented: personal delivery, certified mail, or posting on the premises. Because Arkansas doesn't have a detailed statutory framework spelling out notice procedures the way URLTA states do, clear documentation of how and when the notice was delivered is especially important. For fixed-term leases, the lease expires at the end of the agreed term without additional notice required unless the lease itself specifies otherwise. If the tenant remains after the term expires and the landlord accepts rent, the tenancy typically converts to a month-to-month arrangement under the same terms. Landlords who don't want this automatic conversion should send written notice before the lease expires, making their intentions clear, and should stop accepting rent after the term ends. For week-to-week tenancies, the notice period follows the 1 rental period rule. 7 days notice before the end of the weekly term. Now let's cover termination for cause. And this is where Arkansas's unique framework comes into play. For non-payment of rent, Arkansas does not require a lengthy statutory notice period before the landlord can take action. The landlord must provide the tenant with notice that rent is due and demand payment. If the tenant doesn't pay, the landlord can pursue eviction through the courts. The process can move quickly because Arkansas doesn't mandate the extended cure periods, 5 days, 7 days, 14 days, that most other states require. In practice, most Arkansas landlords provide a written demand for rent and allow at least a few days for the tenant to pay before filing for eviction. While this isn't strictly required by a specific statutory provision, it demonstrates good faith and strengthens the landlord's position in court. Judges generally expect landlords to have made a reasonable demand before seeking judicial relief. Arkansas's unlawful detainer statute, found in Section 18.60.304, provides the framework for eviction proceedings. The landlord files an unlawful detainer action in district court, and the court schedules a hearing. The process is designed to be efficient, and hearings are typically scheduled within a matter of days to a couple of weeks. For lease violations other than non-payment, Arkansas's approach depends heavily on the terms of the lease and the nature of the violation. Because the state lacks a detailed statutory cure period framework, the lease itself is the primary governing document. If the lease includes provisions for termination based on specific violations, including the notice required and whether the tenant gets an opportunity to cure, the landlord can enforce those provisions. In the absence of specific lease language, the general approach is to provide the tenant with written notice of the violation and a reasonable opportunity to correct the problem before pursuing eviction. What constitutes reasonable depends on the nature and severity of the violation and is evaluated by the court on a case-by-case basis. For serious violations, including criminal activity, drug-related offenses, substantial property damage, and conduct that threatens the health or safety of other residents, the landlord can pursue eviction more aggressively. Arkansas courts recognize that certain conduct is so severe that it justifies expedited action, and the landlord may not be required to provide an extended cure period for genuinely dangerous situations. Arkansas has specific provisions addressing drug activity on rental property. If a tenant is involved in the manufacture or distribution of controlled substances on the premises, the property can be subject to nuisance proceedings. The landlord has both the ability and the incentive to act quickly, not only to protect other tenants, but to protect the property from potential forfeiture or nuisance liability. Now, let's address the criminal eviction provision, because it's unique to Arkansas and affects how the termination process works in practice. Under Section 18-16101 and related provisions, if a landlord provides proper written notice to vacate and the tenant fails to leave within the specified period, the tenant can be charged with a criminal offense, specifically a misdemeanor for failure to vacate. This criminal provision exists alongside the civil unlawful detainer process, giving Arkansas landlords two parallel paths for removing tenants who refuse to leave. The criminal eviction statute has been controversial and has faced legal challenges, including arguments that it violates due process and constitutional protections. Courts have evaluated these challenges with mixed results, and the practical application of the criminal provision varies by jurisdiction. Some Arkansas prosecutors actively pursue criminal failure to vacate charges, while others are reluctant to use criminal enforcement for what is essentially a civil dispute. Landlords should understand that while the criminal statute exists, the civil unlawful detainer process is the more reliable and predictable path for most eviction situations. The civil eviction process in Arkansas goes through the district court. The landlord files an unlawful detainer complaint, and the court issues a summons to the tenant. The hearing is typically scheduled quickly, often within 1 to 2 weeks of filing. At the hearing, the landlord presents evidence of the grounds for eviction, and the tenant has the opportunity to respond and raise defenses. If the court rules in the landlord's favor, a judgment for possession is entered. The tenant is given a specific period to vacate, and if they don't leave voluntarily, the landlord can request a writ of possession. The sheriff then carries out the physical eviction. The overall timeline from filing to removal can be relatively quick in Arkansas, often 2 to 4 weeks for uncontested cases. If the tenant appeals, the case moves to circuit court. During the appeal, the tenant may be required to post a bond to remain in possession. If the tenant doesn't post the bond, the landlord may be able to proceed with the eviction even while the appeal is pending. On the tenant's side, Arkansas provides limited grounds for early termination compared to more tenant-protective states. Arkansas's lack of a comprehensive Landlord-Tenant Act means that tenant remedies are more limited and less clearly defined than in URLTA states. If the landlord fails to maintain the property in habitable condition, as we covered in our Arkansas habitability video, the tenant's remedies are based primarily on common law principles rather than a detailed statutory framework. The tenant can pursue remedies through the courts, including constructive eviction if conditions are severe enough to make the property uninhabitable. However, the process requires the tenant to work through the court system, and the available remedies are less streamlined than in states with specific statutory repair and deduct or rent withholding provisions. Active duty military members are protected by the Federal Service Members Civil Relief Act and can terminate with 30 days' notice following deployment or permanent change of station orders. Arkansas has several military installations, including Little Rock Air Force Base, Fort Chaffee, Camp Joseph T. Robinson, and the Pine Bluff Arsenal, making this provision relevant to military families across the state. Arkansas does not have a comprehensive state statute providing early lease termination rights specifically for victims of domestic violence. This is an area where Arkansas lags behind a growing number of states that have enacted such protections. Tenants who are victims of domestic violence and need to terminate a lease early should consult with a local attorney or contact a domestic violence advocacy organization for guidance on available options under current law. Some protections may be available through orders of protection or other court proceedings, but the framework is less defined than in states with specific statutory provisions. Arkansas strictly prohibits self-help evictions through its unlawful detainer statute and common law. Landlords cannot change locks, shut off utilities, remove doors or windows, or remove the tenant's belongings to force a tenant out without going through the court process. While Arkansas doesn't have the detailed statutory penalty provisions for self-help evictions that some states impose, such as treble damages or specific dollar amounts, a landlord who engages in self-help faces civil liability for the tenant's damages and undermines any legitimate eviction case they may pursue. Courts will not look favorably on a landlord who bypassed the legal process. Arkansas does not have a detailed anti-retaliation statute with specific presumption periods and enumerated protected activities the way many states do. However, courts recognize the common law principle that landlords cannot terminate a tenancy in retaliation for a tenant exercising their legal rights. If a tenant reports a code violation, makes a good faith complaint, or exercises any other legal right, and the landlord responds by filing for eviction, the tenant may raise retaliation as a defense. The practical challenge is that without a statutory presumption, the tenant bears a heavier burden of proving retaliatory intent. One important practical consideration for Arkansas landlords: because the state's legal framework is minimal, your lease agreement is by far your most important tool for managing the landlord-tenant relationship. Everything that the statute doesn't address, notice periods for specific violations, cure rights, grounds for termination, maintenance responsibilities, consequences of specific breaches, and the process for handling disputes should be clearly spelled out in the lease. In a state where the statute provides broad strokes rather than detailed procedures, a poorly drafted lease leaves you without the tools you need when a termination situation arises. Investing in a well-drafted lease prepared by an Arkansas landlord-tenant attorney is the single best thing you can do to protect your interests. Arkansas's rental market varies significantly across the state. Northwest Arkansas, the Fayetteville, Springdale, Rogers, and Bentonville corridor, has the strongest rental market driven by Walmart, Tyson Foods, J.B. Hunt, and the University of Arkansas. The eviction process in this high-demand market is generally straightforward because demand is strong and replacement tenants are readily available. Little Rock and Central Arkansas have a moderate market where the eviction process works efficiently through the Pulaski County courts. Smaller cities and rural areas have softer markets where landlords need to consider the practical costs of turnover alongside the legal process. Arkansas does not have a comprehensive statutory framework for security deposit returns comparable to most states. The rules regarding deposits are governed primarily by the lease terms and common law principles. Landlords should include clear language in the lease addressing when and how the deposit will be returned, what deductions can be made, and the timeline for providing an itemization. Without clear lease language, disputes over security deposits can become complicated and unpredictable. For the complete guide to Arkansas lease termination laws, visit tenantscreeningbackgroundcheck.com. Subscribe to our channel for every state in our Landlord Tenant Law series.